Welcome to this pre-recorded lecture on personal insolvency, encompassing bankruptcy and individual voluntary arrangements, IVAs. The rules of personal insolvency are set out primarily in parts Roman 8 and Roman 9 of the Insolvency Act, so as you listen to this lecture, you are advised to have your legislation manual close to hand so that you can look at the statutory provisions. Assuming that you want to look at the provisions in the Insolvency Act dealing with personal insolvency, it is likely that this lecture will take you approximately 90 minutes to review. Please also note that the recommended reading for personal insolvency is Chapter 20 in the CLP Business Manual. Before we go any further, ask yourself as to the reasons why an individual, as opposed to a company, might get himself or herself into financial difficulties. The reasons could of course be associated with business. Sole traders and partners are subject to unlimited personal liability for business debts, while company directors can also get into difficulty, for example if a wrongful trading order is made against them, or where they have given a personal guarantee to the bank to help secure the company's borrowing. Individuals can, however, get themselves into financial difficulties for reasons which have nothing to do with business, for example excessive credit card expenditure, gambling, or indeed due to the cost of litigation, for example where an individual has brought an unsuccessful claim for defamation. Anyway, let's move on to now the content of the first slide, headed Introduction. Introduction. As stated, the rules of bankruptcy are set out in Part 9 of the Insolvency Act. See Insolvency Act Section 264 and thereafter. The rules on IVAs are much shorter. See Part Roman 8 and Sections 252 to 263. The main provisions in the Insolvency Act are supported by relevant provisions in the insolvency rules. Although these are not set out in the legislation manuals, these may be referred to from time to time. Broadly speaking, an IVA performs a similar role for an individual as does a CVA for a company. It is a form of rescue, and in the case of an individual, is a way of avoiding bankruptcy. In essence, if enough of the individual's creditors agree to the person's proposals, they become binding on all the creditors, regardless of whether they voted in favour of them or not. Note the existence of another formal alternative to bankruptcy, a debt relief order. For individuals with total unsecured liabilities not exceeding £50,000 and total gross assets, including savings, not exceeding £2,000, an application for a debt relief order may be made by the official receiver following an online application. See para 20.7.3 of the BLP Manual. You may also briefly refer to Part Roman 7A of the Insolvency Act, Section 251A2X. Note also the reference to the informal creditors' negotiation or family arrangement. If an individual knows that she or he cannot pay debts on time, they can always try to reach agreement with the creditor as to a revised timetable for payment. The problem with this, of course, is that, in the absence of consideration, an agreement of this nature is not binding on the creditor, so the creditor is free to commence proceedings to enforce the debt at any time thereafter. See para 20.7.2 of the BLP Manual. Accordingly, and finally, note the reference to the formal debt respite scheme, or breathing space, which came into force on 4th of May 2020. See para 20.7.4 of the BLP Manual. The alternative to bankruptcy that we will encounter in Group Session 19 is the IVA, but clearly you should appreciate, in outline, that there are other possibilities. Finally, before moving on to the slide headed coverage, please also note the monthly statistics published by the Insolvency Service, and also in the Gazette, for the number of bankruptcy orders, IVAs, and debt relief orders. The statistics for the third quarter of 2024, July to September 24, are set out in the BLP Unit 19 Group Session PowerPoint slides, but briefly be aware that the combined total number of IVAs and DROs, debt relief orders, far exceeds the numbers of actual bankruptcies. Coverage. So what does this pre-recorded lecture focus on? With regards to the question, who can apply for bankruptcy, the rather obvious answer is the individual's creditors, but even there one needs to distinguish between a person's secured and unsecured creditors. The most common secured creditor that an individual might have is the building society. While such a creditor can petition for the bankruptcy of the borrower, see Insolvency Act Section 269, in fact, it is far more likely in practice that the secured creditor will look to enforce its security as a way of recovering its debt, for example by foreclosing on the mortgage. Also, do not overlook the fact that an individual can, himself or herself, make an online application to a special adjudicator for a bankruptcy order. See briefly Insolvency Act Section 263H and the remaining provisions in Insolvency Act Section 263. For the most part, however, this lecture will focus on an individual's unsecured creditor petitioning for bankruptcy and the procedure involved. If a bankruptcy order is made by the court, a relevant question quickly becomes, for how long does the individual remain bankrupt, i.e. duration? You may or may not be aware that as a general rule, the duration of a bankruptcy order is just 1 year. As we shall see later, however, there is a bit more to it than that, simply to state that a bankruptcy order usually lasts for 1 year. We will look at the effect of the bankruptcy order on an individual's property. Well, briefly, the bankrupt estate vests in the trustee in bankruptcy, but you will need to see Insolvency Act Section 283 to identify what is not covered by the term the bankrupt's estate. Also, what about restrictions of personal nature imposed on the individual as a result of a bankruptcy order? The restrictions could be of a professional nature, for example the position of a solicitor under the internal rules of the professional body, i.e. the Law Society SRA, or imposed by legislation. We will look at the role of the trustee in bankruptcy, who incidentally must be a licensed insolvency practitioner. Broadly speaking, the trustee performs a similar role to that of a company's liquidator, realising the individual's assets with a view to paying off the creditors. Unlike in the case of a company, however, the bankrupt is not dissolved at the end of the bankruptcy. Instead, the individual will become a discharged bankrupt. So let's move on to the next slide, that is, informal procedures. Informal procedures. We have already mentioned the possibility of the individual reaching an informal agreement with his or her creditor or creditors, that is, a family arrangement, referred to here simply as a creditor's agreement. Other interesting possibilities are leaving the country altogether. In fact, if you take a look at Insolvency Act Section 265, you will see that this will not work, since if the individual has been ordinarily resident in England and Wales at any time in the period of 3 years, ending with the date of the petition, the court has jurisdiction. What about jumping off the nearest bridge? This somewhat extreme way of avoiding bankruptcy is, of course, very much misplaced, even more so in this day and age, i.e. COVID and the post-COVID cost of living crisis. The rules these days are in fact designed to remove the stigma attaching to bankruptcy. As mentioned above, it is possible that a non-culpable bankrupt can be cleared of the bankruptcy order within 12 months. See Insolvency Act Section 279, subsection 1. Following discharge from the bankruptcy order, the individual is generally free from most of his previous debts and is thus able to make a fresh start. So shall we move on to an important alternative to formal bankruptcy, that is, the IVA. As mentioned, the rules for IVAs are set out at section 252 and thereafter in the Insolvency Act. Slide 5, IVAs. You should by now have listened to the recorded lecture on CVAs in the context of corporate insolvency. CVAs provide a route for a company to avoid liquidation. In summary, proposals are put to the company's creditors, and if the requisite percentage by value of debt agreed with the proposals, they became binding on all of the creditors, regardless of whether they voted in favour of the proposals or not. IVAs operate in a similar way for an individual. Note how the slide states that an IVA could be useful when an individual wishes to continue trading as a way of generating funds to help meet the debts. The point here is that it is very difficult for someone who has been adjudged bankrupt to keep trading while subject to a bankruptcy order. In particular, an undischarged bankrupt commits an offence if, while subject to the bankruptcy order, he or she obtains credit exceeding a prescribed amount without disclosing the fact that he or she is bankrupt, or trades under a name other than the name under which they were adjudged bankrupt without disclosing that name. See Insolvency Act section 360. By the way, if you look at paragraph 20.4.6.1 of the CLP Business Manual, you will see what the prescribed amount of credit referred to here actually is. Anyway, an IVA will not necessarily work for everyone who is in financial difficulties. There is always the risk that the individual becomes saddled with paying off the creditors over an extended period of time, whereas by becoming bankrupt, there is the possibility of being freed from the debts within a relatively short period of time. What is right in any given situation will of course depend on the individual's personal circumstances. If a decision is made to pursue an IVA, this will almost certainly be after consultation with an insolvency practitioner. Indeed, a QIP will need to agree to act as nominee of the scheme. See Insolvency Act section 253. The debtor makes an application to court consisting of proposals to be put to the creditors, accompanied by a statement from the nominee that in his or her opinion, the proposals have a reasonable prospect of being approved by the creditors. See Insolvency Act section 256. The court is then empowered to make an interim order. See section 252. Essentially, a moratorium is imposed pending the holding of the creditors' meeting. Please do take a look at Insolvency Act section 252. Note also that prior to making an interim order, the court has discretion to stay legal proceedings, for example a civil claim, brought against the individual. See Insolvency Act section 254. The interim order, moratorium, lasts for an initial period of 14 days after the making of the order. See section 255 subsection 6, although there is the possibility of that period being extended. Anyway, the idea is that the creditors meet at the time and place as directed by the QIP nominee. If enough of the creditors, by value, agree to the proposals, they become binding on all of the creditors. As was the case with CVAs for a company, however, a secured creditor does not lose its right to enforce its security, regardless of what the meeting decides. Also, a preferential creditor of the individual. We came across the concept of preferential creditors in the live lectures on corporate insolvency, for example, employees. Preferential creditors cannot lose their right to be paid in priority to the ordinary unsecured creditors. See Insolvency Act section 258. With regards to the voting majority required, the rules are set out in the insolvency rules. As with company CVAs, a majority of 3/4 in value of the voting debt is required, and, as was also the case with companies, not more than half of the ordinary unconnected creditors of the individual, excluding for these purposes debtors who are regarded as associates of the insolvent, must vote against the proposals. So let's turn our attention now to bankruptcy itself. Basic purpose for bankruptcy. The contents of this slide are largely self-explanatory. Some care should be taken, however, regarding the reference to ending the misery. This alludes to the fact that the insolvent individual himself might wish to make an application to the adjudicator for his or her own bankruptcy. Remember, the changes made to the bankruptcy rules are designed in part to make bankruptcy more attractive to non-culpable insolvents, for example, by providing for the possibility that a non-culpable bankrupt can be discharged from the bankruptcy order at the expiry of 12 months. There is also reference to distribution of assets to creditors. This should make you think about the order of priority for repayment in the bankruptcy. We came across this in the context of corporate insolvency, and the order is similar in the case of an individual, although not necessarily identical. We shall look at this in more detail later on. Anyway, we shall move on to the next slide. Who can apply for bankruptcy? Who can apply for bankruptcy? The identities of the parties who can petition for bankruptcy are set out in Insolvency Act section 264. Note that where an IVA has been agreed to by the creditors, the supervisor of the IVA, or any of the parties who are bound by the terms of the IVA, may also petition for bankruptcy. This is most likely where the individual has been unable to keep to the terms agreed at the creditors' meeting. We will look briefly at the possibility of the debtor himself or herself making an online application to the adjudicator for a bankruptcy order. See later. But the focus here is aimed at a creditor's petition. In particular, we are really talking about an unsecured creditor of the individual. While a secured creditor can petition for bankruptcy, see section 269, it is relatively unusual. The next slide offers more detail about a creditor's petition, so let's move on. Grounds. Creditor's petition. The critical sections of the Act here are sections 267 and 268, so ideally you will have these in front of you at this point in time. The most common ground on which the court will make a bankruptcy order is that the individual is unable to pay its debts as they fall due. Note that the court can also make the order, however, where the debtor has no reasonable prospect of being able to pay, that is, debts due in future. The liquidated unsecured debt in question must, according to Insolvency Act section 268, equal or exceed the bankruptcy level. With effect from 1st of October 2015, the bankruptcy level was increased to £5,000, previously £750. How does the creditor go about establishing to the court's satisfaction that a debtor is unable to pay its debts? We shall consider this next, so please turn over to the next slide headed Proof of Grounds. Proof of Grounds. Creditor's petition. You may well recall from the sessions on corporate insolvency how a creditor could show inability to pay debts as they fell due by serving a statutory demand on the company. Insolvency Act section 268 also refers to a demand in the prescribed form, a statutory demand, being served on the debtor. If the debt demanded is not paid, or secured or compounded to the satisfaction of the creditor within 21 days following service on the debtor, the creditor essentially has evidence that the debtor is unable to pay the debt, so that the court may make a bankruptcy order against the individual. provided, of course, that the debt or aggregate amount of various debts is equal to at least £5,000. You may recall we discussed serving a company with a statutory demand. In particular, we said that the winding up procedure should not be used where there was evidence that the debt in question was the subject of a bona fide dispute. In fact, the same applies here. If the reason why the debt demanded has not been paid is something along the lines of the goods sold to me were not of satisfactory quality, the creditor should not serve the debtor with a statutory demand, but should commence civil proceedings instead. The preceding slide did allude to the fact that if the court is to make a bankruptcy order, there should not be an outstanding application to set aside the statutory demand. The insolvency rules, Rule 6.4 to be exact, do provide for the debtor to challenge a statutory demand within the period of 18 days following service of the statutory demand. There is a real risk where a creditor seeks to use the insolvency procedure for the purposes of debt recovery in the context of a bona fide commercial dispute, but the court will, on application of the debtor, set aside the statutory demand, and in the process of doing so, penalise the creditor in terms of time and costs. If there is no evidence of a bona fide dispute between the parties, then a statutory demand is appropriate. If there is some evidence of a bona fide dispute between the parties, then it may be appropriate to seek summary judgment instead. Really, from the creditor's point of view, each situation must be judged on its own merits. Note finally that there is another way of demonstrating that the debtor is unable to pay its debts. That is, where civil proceedings have been commenced and judgment obtained. Execution has thereafter been returned unsatisfied in whole or in part. The next slide offers further commentary on the procedure to follow from the creditor's point of view, so we shall move on. Slide 10. Applying for bankruptcy. This slide provides a summary of the procedure the creditor will need to adhere to if it is to petition for the debtor's bankruptcy. First, do the grounds for the petition exist, i.e. is there a debt of at least £5,000 owing to the creditor, and has a statutory demand been served on the debtor which has not been satisfied in the following 21 days, etc. At the expiry of the 21-day period following service of the statutory demand, the creditor is free to issue the bankruptcy petition itself at the court. It is important to remember that all of these formalities, statutory demand, petition, including the court fee and deposit, service of the actual petition itself on the debtor, will mean that the creditor will inevitably incur legal costs. The insolvency rules make clear that where the debtor has resided or carried on business in the London Insolvency District for the greater part of the 6-month period prior to the issue of the petition should be presented to the High Court. As a general rule, if the creditor resides outside of London, the appropriate court is the county court, either where he resides or where he has carried on business. One final point to make is that as a general rule, personal service of the petition is required by the insolvency rules. It is possible that the solicitor acting for the creditor will instruct a process server. Again, this will mean that the creditor is likely to incur legal costs. Given the level of professional charges, the creditor may well incur if a decision is made to petition for the debtor's bankruptcy. It may be sensible to consider alternatives. For example, if goods were sold on credit terms to the debtor, with retention of title in favour of the unpaid supplier, recovery of the goods is an option, assuming that they can be located, together with an action in debt. Also, if there is evidence that another creditor has already issued a petition against the debtor, there is little point in the second creditor issuing a further petition. That, of course, begs the question as to how one finds out whether a bankruptcy petition has been served on an individual. The answer to that question is as follows. The insolvency rules provide that where a bankruptcy petition is filed, the court notifies the Chief Land Registrar. Notice of the petition is registered in the Register of Pending Actions and against the title to any registered land in which the debtor is interested. In other words, it is possible to find out whether or not a bankruptcy petition has been issued against an individual. Note that the insolvency rules also provide for the possibility of substitution of creditor, so even if the debtor reaches an agreement with the petitioning creditor, there is the possibility of the court ordering that another creditor be substituted as the petitioner. One final comment to make concerning the statutory demand is that if the creditor in question is owed less than £5,000, it may be pointless serving such a demand since that creditor alone will not succeed in attaining a bankruptcy order. On the other hand, the rules do envisage the making of a bankruptcy order where the aggregate amount of the debts equals or exceeds £5,000. So if there are a number of creditors whose aggregate debt equals £5,000, who are aware of each other's existence, the service of multiple statutory demands and a joint creditor's petition remains a possibility. That's all for slide 10. Let us look briefly now at the position where the debtor wishes to apply himself or herself for a bankruptcy order. Slide 11. Debtor's petition. There has been evidence in recent years that the number of debtors seeking to make themselves bankrupt has increased, possibly since the legislation makes bankruptcy more attractive for non-culpable debtors. On the other hand, whether it is actually a good thing to be adjudged bankrupt is a different question. For example, the impact on the individual's credit rating for future purposes could be considerable. Regardless, since 6th of April 2016, a debtor can no longer petition the court for a bankruptcy order, but instead must now make an online application to an adjudicator especially appointed for such purpose. The adjudicator has the power to make the bankruptcy order on the basis that the debtor is unable to pay his or her debts. That is, existing debts due immediately, as opposed to existing debts due for repayment in future. See briefly Insolvency Act section 266H and the other provisions within that section. Let us move on now to slide 12, Effect of Bankruptcy Order. Effect of Bankruptcy Order. First, note that following the making of a bankruptcy order, the official receiver takes possession of the bankrupt's estate. This is done in conjunction with the bankrupt's duty to submit a statement of his or her affairs to the official receiver within 21 days following the making of the order, section 288, to deliver possession of his or her estate to the official receiver and to deliver up all books and papers pertaining thereto, section 291. Also note the official receiver's power to seek public examination of the bankrupt under Insolvency Act section 290. We mentioned in an earlier slide that where a petition is issued at court against an individual, that the Chief Land Registrar is notified, i.e. the petition is registered in the Register of Writs and Pending Actions. Similarly, the petition appeared against the title to any registered land in which the individual was interested. Following the making of the bankruptcy order itself, the Chief Land Registrar is again notified. In this case, the bankruptcy order appears in the Register of Orders, and again, also against the title to any registered land in which the bankrupt is interested. The official receiver is required to decide within the period of 12 weeks following the making of the bankruptcy order whether or not to summon a meeting with the individual's creditors. See Insolvency Act section 293. This might be because the perception is that the creditors may wish to appoint an insolvency practitioner to assume the role of trustee. Even if the official receiver does not call a creditors' meeting, the creditors themselves, by reference to at least 1/4 in value of the bankrupt's overall debt, can require the official receiver to summon such a meeting. See Insolvency Act section 294. This is probably all we need to say about the content of this slide. Either the official receiver or a QIP appointed by the creditors will assume the role of trustee, and as Insolvency Act Section 306 makes clear, at this point the bankrupt estate, see Insolvency Act Section 283, the bankrupt estate vests by law in the trustee. The next slide deals with the duration of the bankruptcy, so let us look at that next. Slide 13, duration. While it had previously been the case that the duration of the bankruptcy generally lasted for 3 years, the current position is that the usual duration of the bankruptcy order is 1 year. What students should appreciate is that the objective of the legislation is to distinguish between non-culpable, blameless, and culpable, morally blameworthy bankrupts. So as Insolvency Act Section 279 makes clear, a bankrupt is generally discharged from the bankruptcy at the end of a period of 1 year, beginning with the date on which the bankruptcy commences. On the other hand, as Section 279 subsection 3 makes clear, on application of either the official receiver or the trustee, the court is empowered to order that the duration of the bankruptcy continues beyond the 1 year period specified. This may be the outcome where the bankrupt has failed to comply with his or her obligations under the Insolvency Act. A further feature of the legislation is the existence of bankruptcy restriction orders, BROs, for culpable bankrupts, so that restrictions can be imposed on the bankrupt which last beyond the duration of the bankruptcy order itself. We shall look at these further in the next slide, effect of bankruptcy order on debtor. But before we do so, let's make clear the significance for the bankrupt as a result of the discharge of the order. The point is that on the discharge of the bankruptcy order, while the bankrupt estate remains vested in the trustee for the benefit of the various creditors, the individual is generally released from his or her bankruptcy debts. The idea is that they have a clean slate and start afresh. We say generally released from the bankruptcy debts because we should note that there are exceptions to this. For example, if the debt in question was incurred fraudulently, the creditor can continue to pursue the debtor, while in the case of certain other prescribed debts, for example student loans, such debts are not released by the discharge of the bankruptcy. Students should peruse Insolvency Act Section 281, effect of discharge. Anyway, let's now proceed to the next slide, effect of bankruptcy order on debtor. Effect of bankruptcy order on debtor. Before we start thinking about bankruptcy restriction orders, BROs, please remind yourselves of the significance of Insolvency Act Section 360. This section makes it an offence for an undischarged bankrupt to obtain credit exceeding £500 without disclosing the fact that he or she is an undischarged bankrupt, but also an offence to trade in a name other than the name in which the individual was made bankrupt, that is, without disclosing the name under which he or she was made bankrupt. As stated earlier, restrictions of this nature will make it very difficult in practice for an undischarged bankrupt to trade while the bankruptcy is ongoing. While it used to be the case that the restrictions under Insolvency Act Section 360 fell away at the end of the bankruptcy, the law now provides that in some cases, the restrictions under Insolvency Act Section 360 continue, notwithstanding that the bankruptcy order has been discharged. This is by virtue of the concept of bankruptcy restrictions orders, BROs, which are referred to in Insolvency Act Section 281A and Schedule 4A to the Act. We mentioned before that the law seeks to distinguish between a non-culpable and culpable bankrupt. As we've seen, in the case of non-culpable bankrupts, the individual is normally discharged at the end of the period of 12 months, beginning with the date of the bankruptcy order. If we are dealing with a culpable bankrupt, however, I'm pleased to see the list of activities set out in Schedule 4A to the Insolvency Act, which the law regards as involving culpability. Certain restrictions on the individual remain in place, notwithstanding that the bankruptcy has been discharged. As Schedule 4A makes clear, a BRO can last for up to a maximum of 15 years. The minimum period is 2 years, and thus it is possible that there may be long-lasting consequences for an individual who is made bankrupt, which endure for a period of time considerably in excess of the duration of the bankruptcy order itself. So where a BRO has been made by the court, the first consequence to note is that Insolvency Act Section 360 continues to apply to the individual. See Section 360, subsection 5. Secondly, take a look at the Company Directors Disqualification Act of 1986. Not only does Section 11 provide that it is an offence for an undischarged bankrupt to take part in promotion, formation or management of a company without leave of the court, it also provides that the same restriction applies whether there is a BRO enforced against him or her for the duration of the order. Accordingly, it is clear the making of a BRO against an individual by the court will make it very difficult for the individual to engage in business while the BRO remains in force. As CDDA Section 13 makes clear, a person risks imprisonment for up to 2 years if he or she takes part in business through the medium of a company in contravention of CDDA Section 11. You may well have seen mention of bankruptcy restrictions undertakings. There's not too much to worry about here. As Schedule 4A paragraph makes clear, faced with the prospect of a BRO being made by the court, it is possible for the bankrupt to offer a BRU, a bankruptcy restrictions undertaking, to the Secretary of State, lasting for not less than 2 years and not more than 15 years. Turning to some of the bullet points on the left-hand side of the slide, note that under Insolvency Act Section 426A, for example, that while becoming bankrupt does not preclude an individual from standing for election as an MP or continuing as an MP, the making of a BRO against that individual does. What about some other consequences? In the case of a solicitor who is made bankrupt, it is clear that the individual's practicing certificate is suspended, and the person must write to the professional body seeking to have the suspension lifted. It is quite possible that in lifting suspension of the practicing certificate, the SRA will impose conditions. There is no automatic suspension of the practicing certificate where a solicitor enters into an IVA with his or her creditors. All the same, such individual should notify the SRA, which is at liberty to impose conditions on the individual continuing to practice if it deems this appropriate. Finally, note Partnership Act Section 33, which provides for the automatic dissolution of the partnership, subject to the express terms agreed between the partners. NB, think about the open shaking deed, which in the event that the partner became bankrupt, provided for the other partners to have an option to buy out the share of the bankrupt partner and for the partnership to continue accordingly. You should also note that where an individual who is a company director is made bankrupt, if the company's articles are based on the model articles of association, such model articles provide for the automatic vacation by the individual of the office of director. Think also about the precedent service contract for a company director that you reviewed in Group Section 14. In particular, Clause 15 of that contract provided for summary termination of the employment with no compensation in the event that the director became bankrupt. It's time to progress now to the next slide. Which assets vest in the trustee? We mentioned at an earlier stage that the bankrupt estate is defined by Insolvency Act Section 283. Essentially, all property belonging to or vested in the bankrupt at the commencement of the bankruptcy will vest, as a matter of law, see Section 306, in the trustee in bankruptcy. You will see from Insolvency Act Section 283, subsection 2, that there are certain exceptions to this rule. For example, tools of the trade, books, clothing, bedding. On the other hand, note the trustee's powers under Insolvency Act Section 307, 308, and 310. Under Section 307, the trustee can claim any property which is acquired by the individual after the commencement of the bankruptcy. Under Section 308, the trustee can claim any items which have not vested in the trustee by virtue of Section 283, subsection 2. For example, an expensive TV or car which the bankrupt retained in order to satisfy the basic domestic needs of himself and his family, applying the proceeds of sale to provide a reasonable replacement for the bankrupt. Note the time limits imposed by Insolvency Act Section 309 if the trustee is to take advantage of his powers under Section 307 and 308. Insolvency Act Section 310 is also worth considering. If the bankrupt continues to enjoy an income during his or her bankruptcy, the trustee may seek an income payments order from the court, which would require the bankrupt to pay such amount from that income as the court sees fit. The income payments order can last for up to 3 years, and, as Section 310 makes clear, the period in which such order has effect can last beyond the duration of the bankruptcy itself. Before we move on to slide 16, role of the trustee, let's make one point clear. Remember that the trustee has no better claim to an asset than the individual himself or herself has. So, if at the commencement of the bankruptcy, an asset is vested in the bankrupt, but subject to a charge in favour of a third party, for example the bankrupt's house, on disposing of the property, the trustee is obliged to pay off the secured creditor first of all. So let's move on now to slide 16, the role of the trustee. Role of the trustee. Whether the official receiver or insolvency practitioner appointed by the creditors becomes the trustee, either way, the general function of the trustee is the same. That is, to get in, realise and distribute the bankrupt's estate in accordance with the Insolvency Act. See Insolvency Act Section 305 and note the powers of the trustee set out in Schedule 5 to the Insolvency Act. The most valuable and interesting asset from a legal point of view may turn out to be the individual's home, and we shall say a word about that later on. For now, however, note the list of priority which must be followed by the trustee in applying the proceeds of sale of the bankrupt's estate. It is a general point of law relating to securities that a secured creditor can look to the proceeds of sale of a charged asset in priority to the claims of any of the creditors there might be. Accordingly, if the bankrupt's house is subject to a mortgage in favour of the building society, the mortgagee will have its right to foreclose on the mortgage should the bankrupt be unable to keep up with the payments, which he may well be unable to do, and look to the proceeds of sale ahead of all of the other creditors. Insolvency Act Section 328 then becomes relevant. Note how the costs, including expenses and remuneration of the trustee, are next to be paid out of the kitty available to the creditors. Next, we have to consider whether the bankrupt has any preferential creditors. Remember, we came across preferential creditors during the course of the corporate insolvency sessions, certain amounts of unpaid salary due to the individual's employees, and certain liabilities due to HMRC. See Insolvency Act Schedule 6. Any such preferential creditors rank for repayment prior to the claims of ordinary unsecured creditors. If there are insufficient assets to meet the claims of the preferential creditors, such claims abate in equal proportions amongst themselves. Ordinary unsecured creditors rank for repayment after the claims of any preferential creditors. Again, if there are insufficient assets to meet the claims of the unsecured creditors, such claims abate in equal proportions amongst themselves. As Insolvency Act Section 328 subsection 4 makes clear, interest on preferential and ordinary unsecured debts, which is accrued since the commencement of the bankruptcy, is paid next, and for these purposes, interest on preferential debts and ordinary unsecured debts ranks equally. Finally, please note Insolvency Act Section 329. Debts due from the bankrupt to either a spouse or a civil partner are treated by the legislation as deferred, i.e. paid after the claims of the preferential and ordinary unsecured creditors. Before we leave this slide, let's make some comments on the bankrupt's home in the midst of the bankruptcy. First, we would need to determine what interest the bankrupt has, freehold or leasehold, and if leasehold, what the nature of the interest is, or some other interest perhaps, for example the property was provided by the local authority. Remember, following the sale of the property, the trustee has no better claim to the proceeds than did the bankrupt. So if the house is in joint names, with the bankrupt's spouse or civil partner, and subject to a mortgage in favour of the building society, the proceeds of sale will be applied first to repay the amount due to the lender, and secondly to provide the spouse or civil partner with his or her share. Any outstanding balance of the proceeds of sale will subsequently become available to the trustee. Note the reference to some other sections of the Insolvency Act. First, in the case of Insolvency Act Section 283A, the bankrupt's interest in the matrimonial home will revert back to the bankrupt within a 3-year period following the bankruptcy, unless the trustee realises the interest within that time or makes some other arrangement in accordance with Section 283A. This is designed to prevent the trustee from sitting on the bankrupt's home, waiting for it to increase in value before looking to dispose of it. What about Insolvency Act Sections 335A to 337? Before attempting to summarise these sections, we must appreciate the need of the law to strike a balance when it comes to disposing of the bankrupt's interest in his or her residential home. On the one hand, the creditors have a legitimate interest in the sale of the property with a view to looking to the proceeds in order to recover debts due to them. On the other hand, the bankrupt, and quite possibly others living in the property with the bankrupt, such as a spouse and children, need to have somewhere to live. There are a number of possibilities vis-à-vis the bankrupt's property. For example, the properties in joint names with the spouse, on the one hand, to the properties in the sole name of the bankrupt, and there are minor children living at the property with him or her. As a general rule, in striving to ensure a balance, the law prescribes that on any application made by the trustee more than 1 year after the bankrupt's estate vested in the trustee, the interests of the creditors will take precedence. That is, unless there are exceptional circumstances, the bankrupt, his family, and the trustee all know the bankrupt needs to have made alternative accommodation arrangements within that 1 year period. See Paras 20.4.5.1, 20.4.5.2 in the BLP manual. That's enough on the role of the trustee and the order of the repayment of the creditors. We can now look to the next slide, increasing the value of the bankrupt's estate. Increasing the bankrupt's estate. Briefly, with regards to this slide, it should be apparent that the trustee will aim to maximise the value of the bankrupt's estate with a view to paying the individual creditors as much of the debt due to them as is possible. In so doing, the trustee will use all the powers made available to him, and that brings us to powers given to the trustee by the Insolvency Act as follows. Clearly, in considering these slides, you will want to look at the legislation yourself, and the remainder of the voiceover commentary will be kept to a minimum. Slide 18, Voidable Preferences, Insolvency Act Section 340. We came across this concept in the context of corporate insolvency. That was Insolvency Act Section 239. Take care not to get the sections mixed up, i.e. do not talk about Insolvency Act Section 340 in the context of corporate insolvency and Insolvency Act Section 239 in the context of personal insolvency. Note that the period in which the trustee can seek to have an alleged preference set aside by the court is extended to 2 years, ending with the date of presentation of the petition on which the bankruptcy order was subsequently made, where the preference was given in favour of an associate of the bankrupt. Associate is defined by Insolvency Act Section 435, and you should have a look at this for yourself. See also Insolvency Act Section 341. Remember, if the debtor pays off one of his creditors who is threatened to make him bankrupt, and such debtor subsequently becomes bankrupt, all the same, it is quite possible that the court would not make an order for repayment to the estate on the basis that the requisite state of mind of the debtor under Section 340 subsection 4 was not present. Let's turn next to slide 19, Transactions at an undervalue. Transactions at an undervalue, Section 339. Again, we came across this concept in the context of corporate insolvency. That was Insolvency Act Section 238. As before, take care not to get the sections mixed up. In other words, don't talk about Section 339 in the context of corporate insolvency act and Section 238 in the context of personal insolvency. One possible example of a situation where an individual might have given a transaction at an undervalue is where a spouse, often the husband, transfers title to the matrimonial home into the sole name of the other spouse, retaining perhaps a small beneficial interest. Should the husband become bankrupt in due course, on the face of it, he can turn around and say, the property is owned by my wife and my interest in the property is nominal. The content of Insolvency Act Section 339 is quite straightforward. Note that the time period in which the trustee can look to attack the transaction at an undervalue is 5 years, ending with the date of the presentation of the petition on which the bankruptcy order was subsequently made. You should take care to read Insolvency Act Section 341 carefully. If the transaction in question took place outside the 5-year period, ending on the date of the bankruptcy petition, the trustee has no claim under Insolvency Section 339. It would become necessary in that situation for the trustee to look to his power under Section 423, i.e. transactions defrauding creditors. This is considered on the next slide. Transactions defrauding creditors, Section 423. The difficulty with this particular claim, from the trustee's point of view, is that it will be necessary to show that the transaction at an undervalue in question was entered into by the bankrupt with the requisite state of mind. That is, that it was entered into for the purpose of putting assets beyond the reach of a person who is making or may at some time make a claim against him. If the transaction in question took place a long time before the eventual bankruptcy of the individual, the trustee may not find that an easy burden to discharge. Remember also that individuals can give assets away for any number of reasons, for example, as a gift to a loved one, or even as part of a legitimate tax planning scheme with a view to avoiding inheritance tax in due course. Let us move on to the next slide. Restrictions on dispositions of property under Insolvency Act Section 284. Restrictions on dispositions of property, Section 284. In looking at this slide, you should think about the standard search that you have presumably been advised must be done before entering into an exchange of contracts or completion in relation to a property. That is, search to see whether a bankruptcy petition has been presented against the other party before proceeding. This section explains why such a search is essential. Note that under Section 284, any disposition of property made by a bankrupt in the period commencing on the day of presentation of the bankruptcy petition and ending on the date on which the bankruptcy estate vests in the trustee is generally void, except to the extent that it was made with the consent of the court or is subsequently ratified by the court. Slide 22 deals with the trustee's power to disclaim onerous property under Insolvency Act Section 315. Onerous property, Section 315. A short commentary on the trustee's power to disclaim onerous property is set out in Chapter 20 of the BLP Manual. See Para 20.5.1. So that's pretty much the end of this pre-recorded lecture, but before we finish, let's look and see what's coming up in Group Session 19. What's coming up in BLP Group Session 19? The case study focuses on an unfortunate individual by the name of Peter Long, who has been trading under the name of PL Engineering. You will need to read the supervisor's memorandum addressed to you, including the schedule of liabilities and assets, and then focus on the 3 specific matters raised. See document 19.1. You'll also see that there are 7 SAQs, document 19.2, for which answers will be provided on Blackboard, as well as student notes on the PL Engineering scenario. By way of reminder, Chapter 20 of the CLP Business Manual is devoted to personal insolvency. I hope that you found this lecture both interesting and informative. If you do have any questions, please do raise them with your tutor during Group Session 19. Okay, that is the end, everybody. Thank you very much for listening.